Representative Mangum was here. We passed and set up the basic framework for a new public defender system to provide indigent defense here in Georgia. We came back in 2004, and it took us a little longer that spring and winter and spring, as I recall. But we passed a funding mechanism, which ultimately was contained in what was known as EX1, I think was the number of the bill. And that then put in place a system for funding this new indigent defense program, which had been literally years in the making and had the input of many experts and great Georgians who saw the need for this type of system to bring a higher degree of professionalism and some greater uniformity across the state in providing legal services to those who could not afford them. And so the system then actually hit the ground on January 1 of 2005 and came to life fully across the state, except in some number of circuits, and I don't recall the number right offhand, that exercised what we came to know as the opt-out provision. In the intervening years, there came to be some concerns about that program and how it was operating. And those concerns I submit to members of the committee were probably exacerbated in large degree by a case that had been going on, is still going on, down the street from here in the county in which this capital is located. But in response to those concerns, last year this General Assembly passed a resolution creating a joint study committee that was composed of members of the House, members of the Senate, members of the Judiciary, members of the Criminal Defense Bar, public defenders were on it, county commissioners were on it, and others. And we met a number of times over the interim and took up a large range of issues and concerns with the program, looking at a way of trying to determine, did we need to make changes? I was honored the Speaker asked me to co-chair the committee on behalf of the House, and I was very pleased to serve on that study committee with Chairman Knox, who is on this committee, with Chairman Martin, who chairs the Public Safety Subcommittee of the Appropriations Committee. Representative Levitas, who is a member of this committee, also served on there. And it was really a bipartisan group of legislators from both chambers, along with the other experts that came to the table. And we looked and had a very candid look, I think, at all of these concerns. I frankly approached the sessions not really sure of the direction that this whole thing would go in. Frankly, it was my view that this program is a program worth saving, and I still believe that very, very strongly, that it is a program worth saving. I understand, though, that there are those who believe that it just needs not just tweaking, but some major overhauls. And so you had different viewpoints that came together to have this discussion, and try to reach some consensus on what it was that we needed to do. And while the work of that group was going on, I think one of the most positive developments occurred for the future of that program, and that was having a former member of this body, Mac Crawford, become the director of that program. And frankly, nothing has happened more that makes me more positive about the future of that program than having former Representative Crawford over there, because I think he brings a combination of common sense, legislative and political experience, and many other good experiences that will enable him, as he has already done, provide outstanding leadership over there. What you have before you is essentially the consensus of the work of the study committee. And let me add that you know, as I was telling a reporter yesterday who was questioning me about one specific piece of that puzzle, I am not wedded to every single component in here. I dare say that the other House members are. I dare say that this committee and the House will produce a document that the Senate will be wedded to. I think on the whole, it is a way that we can basically say that we recognize that for this program to survive, we've got to have some change. But I think this is measured and deliberate change as opposed to more fundamental and drastic change, which I think, quite frankly, we're not to the point of needing, particularly given the new leadership that's over there. I think what it does is on a whole, is bring a greater degree of accountability. I think it insists on some better management practices, particularly at the state agency level, all the while recognizing that throughout the entire discussion, and I think the other members who served on the study committee will agree with me, that we really never heard anything other than positive comments and praise for the people out in the field who are actually doing the work in the offices on a day-to-day basis. They are not the problem. They are actually, I think, a big part of the solution. And I hope this committee will join me in recognizing that. But I think that this reflects a measured response to the concerns that many people have, and incorporates a lot of different ideas, and virtually all of these ideas, and these are ideas that came from the committee, some of which in the House leadership was a vital part of the discussions, and they've asked for some input, and some of that's in here too, and I'm pleased to have that. But I think that you know, everybody's open to comments, looking at ways to make it better. I certainly am, as the co-chair of the committee. At the end of the day, I think what we want to do is take to the House a document that really addresses what this House believes to be the best way to move forward. So with that, Mr. Chairman, with those comments out of the way, I will, and I'll do this as briefly as I can, understanding that there are a number of items in the legislation, and if I go too fast, I'm sure that somebody will call me down. I'm working from LC 293190, which is the most recent version, and we've gone through. I'm sure Ms. Travis knows how many times we've redrafted this, but yes.
Mr. Chairman, just wanted to ask, would you like to take questions as we go through the sections, or you want to wait till the very end?
You are the chair until Vice Chairman Mumford evicts you from that position. So
I'm about to give that up in just a second, so we just want to get those guidelines straight before we move it over.
I am simply an humble and member of this committee at this point.
You're still my chair. I'm going to turn it over to Vice Chairman Mumford at this time.
I guess he wants me to make that decision at this point. You got it. Let's go ahead and why don't you go through the sections of the bill, Chairman, and we'll hold questions till the end.
Okay. Sections 1 through 3, rather, basically adds a new provision in Title 15 related to the appointment, and this is probably not under the category of tweaking, to be honest with you. There are some proposals in here I think that are fairly significant. I think this one is. But this one adds language in Title 15 related to the appointment of senior judges. That would provide that senior judges would not be appointed to preside in criminal cases where the death penalty was being sought. And that's the effect of Sections 1 through 3. Sections 4 through 8 make clear that it's the responsibility of the Superior Court Clerk's cooperative authority to collect and disperse funds paid to the clerk of the court and the sheriff for indigent defense funding, and that these funds currently go directly to the GPDS council. This would reroute that funding. Section 9 came about because there was a lot of concern in the hearings that we had over the lack of enforcement and lack of collection of the $50 application fee that the original law provided for individuals who wanted to have legal counsel appointed through this program. We saw some statistics that were frankly very, very disappointing from many circuits where this is apparently is just was basically being ignored. Section 9 provides that when that at the time of posting bail or bond, that the lesser of $100 or 10% of the amount of the bail or bond would be added to that amount, so that that's in effect a doubling of that amount, but not to exceed, but with a cap on it. Section 10 provides that the sums collected from the bail add-ons would be paid to the Superior Court Clerk's Cooperative Authority, and 50% of that would be deposited into the general treasury, and the other 50% would go to the county where it was collected if that county had a procedure to verify indigency. And if there is no procedure in that particular county, then it would go to the general treasury. Section 11 deletes existing language providing that it was the intent of the General Assembly that certain funds were to be earmarked for the council. Section 12 provides that a defendant requesting indigent defense services would pay the $50 application fee unless there is a hardship. And if there's a hardship at the time the application was made, then the fee could be waived and paid as a condition of probation if there were a probated sentence at the end of the case. This section also provides that the $50 application fee would be sent to the entity providing legal defense, and the intent is to send the entire $50 fee to the counties as long as the entity has a procedure in place again for verifying indigency, and if it doesn't, then that sum would be deposited and routed to the state general fund. Section 13 makes a change with regard to eligibility for appointment in misdemeanor cases by providing that those accused of a misdemeanor, that the indigency standard for those accused of a misdemeanor would be 100% of the federal poverty guidelines. The current law is 125% of the guidelines. This section also removes language referencing a conflict defender office to be consistent with other parts of the bill that will change, and you'll see this as we go through it, how conflict cases will be handled. Section 14 of the bill changes the composition of the council. At the present time, there are 11 members. This language would add an additional 4 members so there would be a total of 15. The new members would all be appointed by the governor and would be elected county commissioners from different geographic regions of the state. The county commission members would serve for a term of 4 years and would be appointed in consultation with their association, and would only be eligible to serve during the period of time that they actually were in office as an elected county commissioner. Section 15 authorizes the state auditor to perform an annual audit, which would include all expenditures made by GPDSC by revenue source, including each county governing authority's expenditures made for their indigent defense expenses. Section 16 changes the qualifications for the director of the state council, which by requiring 7 years of experience in the practice of law. Current law requires only 3 years. It provides that the director would provide assistance with death penalty cases and establish mental health and capital defender programs. And that's because under this proposal, we're bringing under the council director the mental health office and the capital defender division, which right now are separate entities. And this section also gives the director the authority to evaluate the job performance of every circuit public defender in the state. Section 17 provides that the council will account for all monies received from each governing authority. One of the things that kind of came up during both the study committee as well as the legislative oversight committee is there was some question going back in time a little bit in terms of accounting for funds, and this will build it into the law. Section 18 removes the requirement that the council promulgate standards. Instead requires that they post proposed rules and regulations for review, including the date on which the rule or regulation takes effect. Section 19 removes language related to CLE for circuit public defenders. Section 20 requires that the council prepare an annual report of funds received and expended, including monies received from cities and counties, as well as a 3-year cost projection and anticipated revenues. Section 1 makes some changes to the Legislative Oversight Committee. The LOC was part of the original legislation back in 2003. It does two things. It removes the language which now requires that the LOC approve the standards of the council, and also reduces the number of times that the Oversight Committee must meet each year from 6 times to 3 times. Section 22 changes language that relates to the selection panel, instead referring to the supervisory panel, and that's to be consistent with other parts of the legislation. Section 23 changes language relating to the mental health division of the council, and this is part of the overall scheme to bring the mental health division under the supervision of the director of the council. Section 24 and 25 changes language related to the Capital Defender Program. Section 24 moves the current language to another code section, but doesn't make substantive changes. And again, this is part of putting that program under the director. Section 25, though, does have a substantive change regarding that program by providing that where there is a conflict of interest in a capital case, the director will appoint counsel and contract with the attorney for payment using a flat fee structure when feasible. Current law provides for the judge to appoint counsel and doesn't make any provision for a fee structure. It goes on to provide that some division of payments between the counties and the state in capital cases, by providing that the state would pay the first $150,000, that the next $100,000 on top of that would be split between the state and the county, and then the next $100,000 would be split 75% to the state and 25% to the county, and then any fees in excess of $250,000 would be split equally. And then finally, this also establishes that the council would establish guidelines for expense requests for fees, expenses, expert witness, travel and accommodation, and other costs. Mr. Chairman, let me go back to Section 19. I misspoke. That did not remove anything about CLE for CPDs. It simply made corrections for some cross-referencing. So we're not suggesting that they violate the state bar rules in terms of CLE or permit them to do so. Section 26 changes the makeup of what will now be referred to as the local supervisory panels. There would be 4 additional members appointed by the governor, who will be members of the governing authority of the county. The version you have in front of you provides that chief public defenders would be appointed for a term of 2 years. Currently, they are appointed for a term of 4 years. And it also provides that a CPD may be removed without cause by a 2/3 vote of the council. And it further provides that the supervisory panel will meet at least semi-annually to review the performance of the circuit public defender. And if the supervisory panel finds that the PD is not performing up to standard, it can adopt a resolution seeking review of its findings by the state council, which would then be required to take action on the request within 15 days and issue and then to act on it within 15 days and issue a final decision within 60 days. Section 27 allows a CPD to go to another circuit for help in a conflict case. Section 28 is a significant change to what is current law by requiring that a defendant who requires the services of the public defender make the request, and that the public defender see the defendant within 5 days after the request for services has been made. But the defendant must have contact with an employee of the office within 3 days from requesting counsel. Section 29 provides that an indigent defense coordinator would determine whether the any detainee, is an indigent person and eligible for the services of the program. Section 30 provides for salary and cost of living increases for public defenders. Sections 31 and 32 removes language relating to the council's budget and requires the council to submit a budget estimate to the director of OPB. Section 33 allows the local office to employ additional staff if provided for by local law and funded by the county governing authority. Section 34 prevents a circuit public defender or any assistant in that office from serving in a judicial office, any judicial office. Section 35 adds language related to rules and regulations to basically make it consistent with other parts of the bill. Section 36 provides that alternative delivery systems will receive the same funds that opt-in circuits receive. Section 37 simply strikes some language to make it consistent with other parts of the bill. Section 38 basically does the same thing, except it makes some language changes to provisions regarding repayment of attorney's fees and removes language related to the intent of the General Assembly regarding availability of funds through the appropriations process. Section 39 provides that counties will appoint a person to serve as an indigent defense coordinator. It allows the counties to determine the scope of the position and to fund the position, and require that the governing authority will advise the Circuit Public Defender Office within 24 hours of each person who has applied for services by making application for those services. And the final change is the removal of language related again to the mental health and capital defender offices, which are proposed under this legislation to be put under the supervision and control of the director. Mr. Chairman, I appreciate the committee's indulgence. I will be happy to try to answer any questions that I can. Jill Travis, I'm sure, will help me. She and Sally, who also will try to help, I'm sure, were at all the study committee meetings. And with that, I will pause and catch my breath.
Thank you very much. Before we go to questions, I just want to say that I now know how you spent your summer vacation, and I'm sure that everyone can find something in here that they don't like, but my hat's off to you and the other members of the committee for the work that you've done here. I know it's been a difficult situation, and I, like you, am dedicated to the proposition that we need to retain our public defender system, and I know the depth of your dedication to that. I think the first member that I had with a question was Mr. Mangum.
Oh, boy.
Or was it?
Well,
it may have been Mr. Setzler.
He can go in first. He can go first. I'll go first.
All right. Representative Setzler.
Chairman, I had not working. I'm sorry.
Don't get too good at using that microphone by sharing that.
Okay, I got it, Mr. Chairman. Thank you. Mr.
I
Chairman.
can hear you without the microphone.
Okay. Mr. Chairman, are you comfortable jumping anywhere in the bill? Did you kind of want to take this in order? I mean, out of.
I'm not sure what I'm comfortable with, but I'll try to answer your question.
Okay. Again, Mr. Chair, there's a lot of things here that are I think there's an awful lot of housekeeping kind of cleanup stuff. One thing that I zeroed in on that I mentioned to you, I think yesterday on the floor, that I'd like to just raise is, and as I looked through the language, just kind of wanted to get the philosophy of the committee, and I know there's more to the story than meets the eye so often.
Chairman Knox was our philosopher.
Okay.
So I may defer to him.
Okay. In section 28 on page 27, and if you could give me a sense of the, I guess the level at which it's realistic that 72 hours after someone's taken into custody, they can have access to counsel. I mean, I know there's got to be some context to that. It does seem like a big change, taking access to counsel from 72 hours after someone's taken into custody as our current standard to 72 hours after a request for counsel, they can talk to someone that's within the public defender's office, a staffer, and then a total of 5 days before they get counsel. That seems like a big change. I just ask you if you could kind of share the thinking there. And I did have a specific question, but it just kind of the overarching thinking that kind of drove that change. Is there
to go from 3
to go from
to 5?
3 days after confinement to 5 days after request, in essence?
Well, number one, the law, the current law really doesn't spell out how it's to work. I think that what has happened is that there have been some practices develop around the current law that kind of make that work. I think that what was at work there, and you and I had a conversation about this yesterday, and you know my view on that. I think that's a fair subject for honest disagreement. I think that the concern was if we're taking the function out of the public defender's office of qualifying applicants for eligibility, that there was a concern that it would not be feasible then to meet that time period. So that was, I think that's as probably as succinct a response as I can give you to that.
I guess my question is, and indulge me if there's some process things that I'm missing, but if you've got an indigent person that's taken into custody for a serious felony, and their investigator comes to them 6 hours after they're taken in, or the next morning and wants to question, or even that night wants to give them some pretty serious questioning, and he says, "I don't want to talk to anybody. I want to see an attorney." Is it true that from that point it would be 5 days before he could have counsel, or is there some other provision where he could get counsel before he talked to an investigator and answered questions?
Did your scenario have the individual, the detainee, making an application?
Well, let's kind of take it from the perspective of a guy that's, again, he's booked for a violent crime, taken in, book him, put him in the cell, and hour and a half later, an investigator shows up and wants to ask him some questions. And he's watched TV before and realized, I don't want to talk to these guys. I want to make sure I've got counsel before I say a word. And he says, "I ain't talking to anybody. I want counsel, and I'm not going to talk till I get it." I don't know if that represents an application. I'm certain he doesn't know what that means. He just wants to see an attorney, and he doesn't know. He knows he doesn't have money to pay for one. How would that? I mean, as I read this, as a layman, it would seem he would have access to counsel. He would be assured of having that within 3 days. I don't know how that normally works, but how does that affect that guy who wants to see an attorney before he talks to the investigator? I guess is the question.
Jill, you want to? I see you looking at me.
Well, the difficulty is current law doesn't address that situation, and the attempt here was to try and clarify it a little bit, recognizing that the writing for this is dealing with this particular scenario you've given, as well as the scenario when somebody's out on bond and they show up for arraignment,
Sure.
and they want to qualify. So you're writing for both of those scenarios. The truth of the matter is that there is an absence of information here as how does that communication in the interview room, like we see on TV when the person says, "I want an attorney," does the sheriff deputy walk out of the room and go, "Hey, Mr. Public Defender, he wants a lawyer"?
Right.
How does that actually work? I think in real life the way it works now is depending on the jurisdiction, in that particular scenario, if there's a relationship between the deputy and the public defender, that might actually happen. That call might actually be placed to do it, but that's the difficulty in writing this, is how to get that communication down the line. There are certainly jails where investigators from public defender's offices are there. They get the applications when the person shows up for the bond hearing the next morning. They qualify the person, and then someone from the public defender's office is there. The language here does say not more than 5 days. So, and I know from the study committee meetings, one of the issues that was brought up from a public defender was that 72 hours would be better at 3 business days to take into account holidays and weekends, and sometimes that 72 hours is difficult. So
I guess my thinking is that if a person's booked in that circumstance, they'd say, "I want an attorney," and then the investigator looks at him and says, "Well, what do you mean by that? Do you want to call? Do you have a buddy that's an attorney? Do you want the yellow pages? Do you have money to engage an attorney?" And he'd say, a lot of guys would say, "There's no way I can afford an attorney," or "What does an attorney cost?" They'd work through all that, and he'd realize he didn't have the money to hire one, so didn't have money to hire Representative Knox. So he's going to ask for. I think it would kind of be coached towards, you need a public defender, and from that process, it would just seem that I don't know, Mr. Chairman. I'll leave it there, but I do have a concern. I can see someone sitting in jail for 3 days, just kind of cooking on this and kind of mulling over this. What's this mean? And 5 days, the psychological impact of, oh my gosh, what's going to happen, without being able to talk to counsel, to me is might lead someone to share facts and talk, and whereas if they had access to counsel early in the process, they would have been told in no uncertain terms, you need to just not share any facts. And again, that's an access to justice issue, and that's just a concern of mine. So as we talk about this is probably my only real concern with the bill, and I'll leave it there. We can just, for other members to come in. Sure.
Representative Mangum.
I have a number of concerns, and I have really a number of concerns, and let me say thank you for your hard work. I had a little to do with the first one that we tried to place in place, and I guess I'm going to go ahead and try to get the easy ones out first. Section 3.1. You have 4 members of the council shall be county commissioners. You're expanding the board for a political reason. I would venture to say page 13. Page 13. In line with my vigilance to stop the schoolhouse to jailhouse pipeline, one of the ways I would ask I know you would probably have to get this approved by someone, but I'd like to get your feeling if you would give me some indication. If we struck where it says 4 members and just said 2 members and then added a 3.2, and the 3.2 would be the following amendment. It would read, 2 members of the council shall be the president or designee of the Georgia Association of African American Attorneys and the president or designee of the Gate City Bar Association. As you may be aware, those are 2 organizations that are predominantly African American, and in light of the way the study commission and a number of the people, in light of, not to even justify it, but I would be glad to if you want me to do so, but in light of the way the system has been run to this date, and in light of the clientele of the public defender's services, which you, at one time, that was a factor, and recently it has not been, but as you are aware, that is a statewide organization as well. Those are the 2 major organizations that represent the interests of persons that look like me who happen to be lawyers. What is your feel and what is your understanding of whether or not that's something that you can give an opinion on today?
Representative Mangum, I think what you've given me are 2 different opinions.
Okay.
And if I don't respond to both, then please let me know that. Number 1, it's my understanding that you would propose that on page 13 in section 3.1 that we reduce the number of members of the council who would be designated as county commissioners from 4 to 2. Is that?
That is correct,
okay.
Sir.
I would not agree to that one, and I'll come back to that in just a moment. Now, your other suggestion, I was looking, and I'm assuming that you would put that organization's representative on page 14, subparagraph little c.
Well, 3.12. 3.2. You have a 3.1 where you add the 4 members, and then it would actually be a 3.2. Since it's speaking to the same subject matter of the addition of additional members of the council, instead of it'll be page 14, but instead of going between or before number 4, you would have a 3.1, and then you'll have a 3.2. The 3.2 will be additional language that I am currently proposing.
I would respectfully oppose putting it there. However, I would be open, if you will notice down in subparagraph C, there's some organizations that are there referenced that would that are sources for suggestion for membership for these groups, and I would not be opposed to including that organization there.
If I'm not mistaken, Mr. Chairman, currently
Do you see where I'm talking about?
I do believe that's subsection C.
Mm-hmm.
And I respect those organizations that you have there, but they don't accomplish what is right now an absence of persons of African descent on the boards that are currently doing what they're doing. And I think that this really even takes it further in the other direction, and I see less likely that there will be anybody that looks like me that has an opportunity to have any differing opinions about the way this should be done, or an additional opinion, a diverse opinion. So, with all due respect, is it anticipated we'll be having a vote on this today?
I would hope that we would vote it.
Okay. Well, I always would like to. I haven't had an opportunity to talk to you about any of this, so out of deference to where you are, and I know that's why I say I know that this is the kind of change that would make a few heads turn. But I'd like to at least say that I would like it in subsection C, but I'd like at least to have a vote on it, so that it'll be on record that it's been voted down, so that you know that it's something that those who are in control would know that that's something that there are some people that want to have some input in. And particularly, I know it was not, you did not appoint the committee, but it was very noted by members that looked like me that there were no people looking like me on your council that really came up with this proposal. With all due respect, and I know that you're able to come up with good opinions, notwithstanding that, but in that light, I'd like for it to just be known that I appreciate your good work, and if you would even put it in subsection C that they can participate. I mean, right now, is there anything that prohibits anybody from, you said, as well as public and other interested organizations? Right now, anybody could suggest something, but it really wouldn't mean anything, would it, Mr. Chairman?
Well, I would hope that it would mean something, because we have spelled out in here organizations that we're asking these authorities to talk to. The State Bar of Georgia, for example, which represents every attorney in Georgia, because we're a mandatory bar, or whatever that word is they use, state and local bar associations. We've got an association here. We've got a voluntary association of the GACDL, the Association of Criminal Defense Lawyers, prosecuting attorneys' councils, the group that represent the various judges. So, you know, I mean, I don't think it would at all be inappropriate to include your proposal there. I think to build it in as an automatic member, with all due respect, I could not agree to.
Thank you, Mr. Chairman. Mr. Mangum, I certainly want to encourage everyone here to make any amendments that they want to. I think we have a lot of questions I think the way to proceed with this, to try and finish this, is to allow amendments right before we get to the end.
Thank you.
So if you want to consider that and maybe scratch something out and be ready for that, that would probably be the way to proceed at this point. I'm trying to do these in order. I hope I'm going to get them. I think the next one was Ms. Abrams.
I'll actually wait for it. I'll come back.
All right. I believe the next one was Tom, Mr. Collins.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, for outlining this and as going through it. A couple of questions. Hopefully we can run through them rather quickly. Page 25, line 30. This is a formal question, and your input. This will also probably come as an amendment as well, but I wanted your discussion on it first. Page 25, line 30. This deals with the term of office for the Circuit Public Defenders. I know that the original language was 4 years. We've adjusted this to 2, and I know there's been some concern across. After looking at this and understanding, a lawyer going from a private practice to this, doesn't there seem to be some concern there that that's just a too short of a period, especially when we elect DAs for 4 years, we do other things, that 2 years just is too short?
Well, I may surprise you by saying that was one of the issues that I disagreed with the consensus on, because I think it should be 4 years.
Okay.
I think that's an honest debate that one can have. My own view is I, having been here, as was Representative Mangum, Chairman Knox, and Representative Benfield was here then too, I think. When we established this program, I think there was a lot of interest in making the public defenders comparable in stature to prosecuting attorneys, and so I think that to be consistent, it should be, my own personal view is that 4 does that, and the other more practical reason is when you ask when someone applies for this position and is selected for it, then I think often the case would be that they're probably leaving a law practice, I'm certain I want this document to be reflective of the will of this committee and ultimately this House, and so however the committee feels is the right thing to do there. I'm at odds with the bill on a few points, and that's one of them. But reasonable people can reasonably disagree on some of these issues.
Well, thank you, Mr. Chair. I will be bringing that at an appropriate time later. Another question. You brought up something that I know some in this room will probably fall out of chairs if they're sitting in them when I bring this up. But you mentioned making them on par with district attorneys, in essence, in a sense of status, the other issues. It is my understanding that the base level district attorney salary is $112 roughly $1,000. Is that correct? Roughly.
I just know they make too much. I don't know how much it is.
Well, Mr. Chairman, I'll let that one go, but I'll also say, was there any thought at all about making the pay commensurate as well?
I don't remember a specific discussion at either in this committee or when this program started about making it equal, I guess is what you're saying, or fairly equal.
Right. From a traction standpoint, and I'm not offering if this one is an amendment.
Well,
I'm just saying, what was the thinking here?
I don't know that this would be the appropriate forum for having a compensation discussion, because I know there's another side to that discussion, and I know there's a number of district attorneys in this state that will tell you that they've had secretaries in their offices that have worked 20 and 25 years who are making less than secretaries who just got hired in the public defender's office. I don't know how that came about, but that's an issue I just don't think I don't think it's part of what we're trying to do here, and I would prefer not to make it.
Well, you just brought it. I appreciate your candor with doing it. I'm going to combine my last question. The question concerns when you were looking through this, and it was on page, I had it down at 7, and it concerns the verification issue. How many counties during the subcommittee time, when we're talking about you would get your money concerning if you have a verification system currently in play, how many counties or circuits did you find did not have a good verification system? And if so, why not? And then the question also, which would go to the opt-out provisions as well for counties, I'd like to see some explanation, or at least understand that how the opt-out would work.
I was frantically searching around for Director Crawford because I know that his office had some of that data and may still have. Do you?
I'll be happy to speak offline about that. Again, those are questions I have. In the verification systems are big, and I think a lot of areas, but in mine as well. And I think Section 28 again is another issue that we'll have another discussion about as well. But thank you, Mr. Chairman.
Thank you. I want to go to the opposite side of the committee over here. I think Mr. Everson had a question.
Thank you, Mr. Chairman. A few quick questions, Mr. Chairman. Thank you so much for your work on this. This is an area that is very much in need of review and updating and for all the people of Georgia. But one of my questions, Representative Collins already asked about the verification process for counties that do not currently have this procedure in place. Section 12, how do you determine a measurable hardship? What is the process for that?
Do you have that? Mm-hmm.
Section 12 on your summary.
What page?
First page, I'm sorry. It's not in the bill. It's on your summary.
Oh. The word measure. I don't think the word I may have used that. I'm not sure that word is in the bill.
Yes.
Is it? No. Page 9. I'm sorry. Okay, now what? I'm with you now. It is in the bill.
Yes.
Your question?
Yeah. How do you determine a measurable hardship once the application is placed?
That would be a determination for a judge to make.
Okay, and that judge will have the...
Correct.
Okay. Thank you. Page 2.
Of the bill.
No, the summary sheet, I'm sorry.
Okay.
Working off the summary sheet, not the bill. How did you arrive at the payment formula for the counties?
That was a proposal that was not trying to pass the buck. We had a little bit of discussion about that in the committee, and then I think Majority Whip Fleming actually came up with that proposal. I'm sorry?
It's in House Bill 1251.
Yeah, it's in another House bill.
Okay. That's it, Mr.
Thank you. Representative Benfield.
Thank you. And I apologize. I know the 72-hour notification was discussed when I went out in the hallway, so I apologize if I'm being redundant. But I used to work as a public defender and was assigned to magistrate court and handled all those initial public defender representations of indigent cases. And this section, to me, I think it's murky as to how the referral is made to a public defender. I'm looking at page 28 at the top. That's the 72-hour section. It's unclear to me how, I'm assuming it's the jail, would be charged with ensuring that notice is sent to the public defender's office, that somebody has made a request for a public defender. To me, it makes more sense, and I was not privy to the hearings, but it makes sense. I was assigned to the magistrate court to process these folks. Why not just have the magistrate judge, when they make that initial appearance of 48 hours that they're arrested without a warrant and the 72 hours that they're arrested with a warrant, they're brought before the magistrate judge anyway. Why not put the onus on a magistrate judge who has a law degree and there's some accountability, and it's in open court that they notify the person at that time
that they have a right to a public defender and have the public defender available. That makes more sense to me than charging the jail with that. Or am I missing something?
No, that's such an excellent suggestion, because I think I made one very comparable to that in the study committee, that I thought the magistrate court was an appropriate way to do this. You mentioned someone with a law degree, and I know that one of the points that came up was the fact that in many Georgia counties we don't have magistrates with law degrees, due to that population issue. The other thing about it being murky is I don't think it's any murkier than the current law started out being. It sort of got worked into a system. And the final point I would say is that the other concern was that by waiting on a magistrate, that on average we would probably extend the time, maybe even past the 5 days, depending on how frequent. Again, there's many rural counties particularly, and I don't know how the metro counties do this, but many rural counties where you don't have these hearings, that frequently. So that was a concern.
If I may follow up, my understanding of the law is that a defendant is entitled to a 48-hour hearing if they're arrested without a warrant, and a 72-hour hearing if they're arrested with a warrant. So I don't know how these counties are getting away with not bringing a person in front of a magistrate. And I was, I guess, somewhat spoiled being in Fulton County where all the magistrate judges were attorneys, but I still think a magistrate, whether or not he or she has a law degree, is going to be, no offense to a deputy, but they may be somewhat more qualified since they deal with this issue on a daily basis. True. As opposed to whichever deputy happens to be on shift at that moment. I think they would be more qualified or in a better position to determine eligibility and appoint a public defender then and there. That system worked well when I worked in Fulton County. I think it was one of the things that did work in the Fulton County court system. It seemed to go fairly smoothly. So I'm glad to hear that you thought that, you looked at that as well. I would just ask you to reconsider. I think that would be more effective. You said it's better than the present system. I don't think the present system's all that great.
Ms. Benfield, we had talked about if members are going to propose any amendments, that we're going to do that at the end. So we're trying to run through
whether I
comments.
propose an amendment or not is based on the feedback I'm getting from the chairman on this.
You want to jump in? Let me bring Jill into this discussion if I could.
Leaving out the issue of communication of that request. But under this bill, and possibly, and most probably under current law, within 72 hours, that person would be entitled to counsel. Under your proposal, that person would be seen by a magistrate within 72 hours, and then would have another 3 days before they'd see an attorney. So your proposal would extend the period of time if you delayed it to a magistrate. And the study committee was trying to keep the spirit of the 72 hours as close as possible.
Can I make a comment?
Sure.
Well, my proposal is that there be an attorney present at that initial hearing, and they would be available for representation right then and there at the 72-hour hearing. Perhaps that's not realistic. The way I read this, and I see your point, it's a good point. If they're taken into custody and immediately have the wherewithal, they're not high on drugs and they're not mentally incompetent, and they immediately have the wherewithal to request an attorney, I see the advantage in this current language where they would have the right to request an attorney right then and there, and then the clock would start ticking. But the way I read this is the onus is on the defendant to make that request, and if that request is never made, I don't see how an attorney is appointed. I don't see a provision here that provides for where an indigent defendant does not, in the event that they don't request an attorney, that they're given counsel. And my concern is particularly someone who might have addiction issues or mental health issues, or they're just not, they they're uneducated, they don't know their rights, they don't know to ask for counsel, and all too often that is the defendant that the criminal justice system sees.
It was my sense that the will of the study committee was that there be some onus on the defendant to request counsel.
So if I can ask, what happens, Mr. Chairman, in the case of someone who is mentally ill or who is high on drugs? I guess eventually they would come off of it, or someone who just doesn't know to ask for a counsel. What happens in that situation under this wording?
Well, at the risk of sounding light, I guess probably the same as happens under the current system,
Which I think is flawed.
So I mean, I don't know how you. I mean, I'm open if somebody can fix, all of these problems with that. I mean, but we didn't really look at changing, that the way it's currently structured.
I do have more questions, but I'm happy to let others ask, and they may ask my question. I can come back later.
All right. Thank you. Representative Knox.
Thank you. Mr. Chairman, I recall us having this discussion about this issue, but I also recall that during the time that we were going through the opt-out programs, that one of the deficiencies that was cited most frequently was that so many counties were ignoring or not meeting the requirements of the 72-hour requirement. And while the bill still cites the 72-hour requirement, I think we really got more than 72 hours now, don't we? Basically, we got 5 days instead of 3.
Well, you have 3 business days for the person to be seen by an employee of the Circuit Public Defender Office, which there was some testimony in the study committee that the first contact that the defendant would have is with an investigator with the Public Defender's Office. So we sort of incorporated that in this definition.
Well, and we may not be able to resolve this, but I think we need to be looking at the issue. The magistrate court judge, the deputy, an official, the investigator from the public defender's office, none of those people are attorneys. That's what this whole deal is about, providing an attorney.
Mm-hmm.
And so, I could send my grandmother over there, and that really, she's a nice lady, but, that doesn't cut it. She may know everything I know, but she's still not an attorney. And she's not the person that we want. That's not what the law says. That's not what the Constitution requires. So, I'm not sure that we're really hitting the mark here. As a practical matter, I think what happens is by the time they get to the jail, first of all, the only ones that land in the jail without going through CID are the people they don't really care about anyhow. There's just a bunch of fish they picked up and they're throwing them in the hoosegow. The ones that are really serious offenders and really need counsel, they don't end up over the jail until they've done one of two things. They've either given up all the information the cops want, or they've dummied up and said, I want a lawyer. That's the only people that are going to be over there in the jail for you to talk to on a 72-hour hearing. So, giving them 5 more days, I'm not sure I understand it what I understood you to say is we're writing it so that because we have this problem about, and I'm not fussing at you, I'm just saying we're writing this language. Okay, well I am, but we're writing this language that to make it so that we can accommodate the issue of whether or not they're indigent or not. Is that the primary focus, or did I hear that? If you don't mind, I'm asking the Legislative Council.
No,
Mr. Chairman.
I have no objection
Okay.
to that. I need the break.
I think that there is a combination of issues here, and there's a combination of now. Let's say that the person that's in the interview room is wealthy, but doesn't want to use their money to get a lawyer, or whatever the circumstance. They don't actually qualify. I mean, you have not only the qualification for indigency, but the communication of the issue. And I agree with you that perhaps this could be better worded.
Well, I guess one of the things that could happen, and it doesn't, I'm not sure it even has to be in here, but maybe something we want to think about is that there's nothing to prohibit the public defender's office or whomever from sending an attorney regularly to the jail to see everybody that's in there, regardless of whether, if they're still there, they need somebody to tell them two things. The first one is shut, and the other one is up. And that's all you need to do. But you know, I think that I'm not sure that needs to be in code. I just think that's something that, based on the principles that we're trying to adhere to, and the spirit that we're trying to get to. I'm not sure. I understand the difficulty that you're talking about, but it might be something we might want to revisit before we get finished with this entirely. I'm not offering an amendment. I'm just.
I understand.
Add one more thing. There was some testimony in the committee, you might recall, that there was a sense that public defenders were sort of fishing for clients, that they were down at the jails getting more clients than, getting everybody signed up, so to speak. And so that was another reason. In other words, offering services before anybody even asked for services. And so, again, this was an attempt to get that issue.
Okay. I'm not fussing at you, really.
Anything further?
You know I love you.
I'm going to move on to somebody else.
Thank you. Yes, please do.
I believe Ms. Bird, Representative Bird.
That's me. Yes, thank you very much.
Just trying to make sure. It's hard to tell. I'm not used to this infernal machine up here.
Thank you very much, Mr. Chairman. I'm looking at section 16, and it talks about, page 16, section 16, page 16, and I just want clarification. And it's on line, it's section 2, line 3. The director shall establish a mental health advocacy division and Georgia Capitol Defender division. Are these going to be establishing two new programs?
No.
No, okay.
No. At the present time, there are divisions over there that are not under the director for whatever reason, the way it was created here a good number of years ago. And so basically what this legislation would do is bring both of those divisions under the director's tent, as it were, under his or her supervision.
Okay. And so that would not require any additional funding?
Technically, no. I can't sit here and tell you that there's not going to be additional funding with the Capital Defender program in this state, with all the issues that I think surround it from time to time. But no, I mean, it's not new programs.
Thank you.
Should have greater efficiencies, I think.
Representative Abrams or Jacobs.
It's only funny when he does it. Mr. Chairman, thank you for the work done on this. I had two questions that relate to indigency. I noticed that there are two sections that increase. One section, it's section 13 on page 10.
Okay.
Line 26. I noticed that we are decreasing the threshold for indigency, and I was wondering if you could talk about it a little bit, given that there's a great deal of concern already about the federal poverty guidelines not being truly reflective of the cost of living in most areas outside of, I think, a small city in Iowa. Actually, this would constitute real poverty. So if you can talk a little bit about the theory behind reducing even lower the threshold.
I'll be happy to do that. This does not apply to felony cases, number one. I think that's an important point to make. It's primarily misdemeanors. And I think this came about as a result of, some of these changes are tough. I don't want to sit here today and tell you that they're not. And if you don't think they're tough, then I would ask you to be patient and wait till the other side of the Capitol gets through with it. With all due respect to our colleagues over there, I can't emphasize enough that for this program to be viable and to go forward, we have to make some adjustments. I mean, that's just the reality. I think the political and the fiscal reality. And this was one of the issues that got factored into that. I don't disagree with the fact that there is the discussion about, you know, the federal guidelines, but I have to tell you that you know, we had to recognize that we had to make some changes here, I think.
And then, if I can follow up,
Sure.
The second question, I'm assuming the answer would be the same, but would like you to speak to it, and that would be Section 9 that doubles the bond fee levied from $50 to $100. It's Section 9, page 6.
6.
Uh-huh.
That was. I think I touched on this a little bit in my opening comments. There was I think the word would probably be frustration. Chairman Knox and Representative Levitas, who left the room, but I think the word would be frustration on the part of many members of the study committee over the really low rate at which we were collecting that application fee that was part of the original bill or law. And so this was sort of put in there, I think, to help the local governments kind of offset some of their expense. And that was really the rationale for that.
Thank you.
Thank you.
Is that all? Thank you. I'm not sure, maybe Ms. Benfield? Do you have your...
I had more questions before, and I just wanted to give others a chance. And actually, some of my questions were addressed. I just wanted to come back briefly to one of the points raised by Representative Abrams on page 10 with that Section 13 with changing the guidelines. You said it just applies to, well, you said that applies to misdemeanors. It does not apply to felonies, but it does apply, as I read it, to felony probation violations. Mm-hmm. So persons in those situations could be facing considerable time. Would you be amenable to amending that to state misdemeanor violation of probation? So when someone is facing felony time, this more stringent test for meeting indigency would not be applied in those circumstances. And the other concern I have with that list is the juvenile offenses. I think certainly there's some cases where juveniles especially need to have representation, and I would ask your consideration of deleting the juveniles from this more stringent test.
Well, I'm looking at, as to the juvenile issue, lines 30 and 31, we're already leaving we're already I'm looking to see how that is redundant.
Yeah, that is.
Well, to answer your question about felony probation, Representative Benfield, I mean, you know, again, I go back to the point I made a couple of other times. We can have honest disagreements over some of these issues, and I think that's one of them. But I think we have to be careful about how we pick and choose what we do to the bill. And I've suggested some ways, I think, that from my perspective, that I would agree to accept some changes. I just believe that we have to kind of be careful at some point and accept the reality that there has to be some fairly significant change if we're going to save the program.
Can you clarify the juvenile issue? Because I'm just doing a cursory
Jill,
reading.
Can you help me on that, Jill?
Because subsection B reads that the juveniles are given the 150% of the federal poverty guidelines, but subsection A includes juveniles.
I don't know. I can see the confusion, but I guess that
That's fine.
it seems to me that language on lines 34 and 36 are supposed to be applying to subparagraph B, the felony, because we're using 150%. So my guess is that juvenile, for example, is a 440 case.
So juveniles charged with misdemeanors would have the stricter guidelines.
That's my reading of it. It probably, I'm trying to understand why that language on line 34 is dropped down. I know that's current code. Why it's back out at that,
Yeah.
at that level. It seems like that sentence actually, that in, for example, should go right after the word defendants, because it seems like that's all having to do with subparagraph C. And probably for formatting that would be better, but that's the way current code is, and if you want to make that change, that would probably be a good thing.
That seems like a cleanup. Mr. Chairman, do you have an objection to that cleanup?
I don't have an objection to that.
But back to the point about the juvenile, I see where subsection A is stating the juveniles charged with misdemeanors have the stricter test. Is that the correct reading? Was that the intent of the committee?
I think that is the intent.
Would you be amenable to removing juveniles charged with misdemeanors out of concern that I think juveniles in particular need to have representation at these proceedings, even if it is a misdemeanor? For juvenile, misdemeanor offense is still substantial.
Are you suggesting that, I'm not sure what you're suggesting.
That we delete the juvenile portion of subsection A. That juveniles in all cases, if they are 150% of the federal poverty guidelines or less, could be eligible for a public defender in Georgia.
Even a shoplift?
Yes.
I don't. I would have to respectfully disagree, I think, with that on a misdemeanor.
Okay. Well, perhaps we could continue that discussion afterwards. I do have one more.
I'm happy to do that.
All right. I just wanted to, well, I'm going to let you finish, but I wanted to tell everybody we've been here about an hour and a half, I think, maybe a little longer than that. While that's probably not a long time in Henry County Superior Court, we need a little break. I do. We're going to take about 5 minutes, but I want you to finish your questions.
Okay, I'll be brief. Page 2, those first 3 sections I see are pulled from, I don't remember the bill, but I know there was separate legislation dealing with the senior judges hearing capital offenses. I'm assuming that's the Hilton Fuller law. Is that really
it doesn't
addressing?
Have a name.
I understand, but is that really how is that addressing that concern? Or my concern is that there may be circuits. I'm just thinking Fulton County. I was speaking with Judge Manis the other day. She's taken senior status, and she already has a caseload of some 200 cases where she is really helping relieve that burden. And I think senior judges serve a great function, and in some cases it may be appropriate to have them handle a capital felony. I understand there's been issues with the Nichols trial, but my concern is, the bad case making bad law. Do we really need this provision?
Well, let me say 2 or 3 things briefly. Number one, I agree with you very strongly that senior judges do serve a very, very valuable function to the judiciary. I can't remember right offhand what the cost of creating new judgeships is per judgeship, but it's a lot of money, and oftentimes
about $167,000 a year.
How much?
About $167,000.
I think it's more than that, but yeah, whatever it is. We're able to utilize very, very fine judges to overcome that and delay that expense oftentimes, and then come in on the conflict case, particularly in rural areas where judges may be conflicted out. So, I mean, I can go on and on about the very valuable role they play. I think that what motivated this was the feeling that a sitting elected judge, still accustomed to having daily interaction or frequent interaction with a governing authority and having to continue to meet a budget and develop a budget and be sensitive to the budget, would be, and theoretically at least, more accountable in cases like capital cases, and would be more sensitive to the expenditure of funds, to put it very bluntly, I think. And that's the genesis behind this idea. I not intended to be a negative comment on anybody. I know that it probably looks like it's kind of a controversial provision. I've had some Superior Court judges privately tell me they think it's a good idea. And that's not their position, and I'm not representing it.
Do they have a position
I don't
on
know.
this?
I don't know.
All right, we're going to take about 5 minutes. I urge the committee members to please come back in about 5 minutes so we can continue. Thank you. Yeah, you got to come back. Is McGarity here? I just was speaking to him. There he is. He's back behind the column.
I tried to take the hiding spot that William Baldwin had. It's a good one. He couldn't quite get away. The Council of Superior Court judges has reviewed this particular bill, and most of it very well deals with policy issues that we are not to weigh in on. First thing, however, that we did feel like we needed to point out, which I was glad to hear the chairman and the sponsor of the bill had already identified this same issue as something he was in favor of. Section 26.
Hold on just a second. Would y'all please close that door one way or the other? Thank you. Sorry. Go ahead, Judge. Some of them come in and never go out.
We only had two exits from our courtroom. The one you walk in and the one I send you out. Only two exits you got. Section 26, page 24, I believe. We agree with Representative Chairman Ralston that getting someone to lead a law practice, 7+ years experience, commit to only 2 years is not sufficient to draw the best qualified candidate.
Did y'all come up with an alternative, or do you just suggest that that's not enough?
I think what it is fine.
All right.
Chairman, we just wanted to point that out. That getting someone to give up a law practice that they built at least 7 years worth, and then to expect them after 2 years they may lose the job without really any reason. 4 years, at least you've got them, as I read it, there's language in there about termination of employment should they not be satisfactory to meet the requirements of the council. The next item was.
Yeah, in fact, I think it's termination really without cause, almost at any time anyways.
So you may have a hard time anyhow,
Right.
but most people are optimistic and they would like to believe that they will do an excellent job that will please everyone and they won't be terminated. As to page 2, sections 1, 2, and 3, we don't disagree with senior judges not handling death penalty cases. When this was on my radar, I believe Representative Fleming's bill was coming out. I did just an analysis. We only have 2 current death penalty cases in the state of Georgia being handled by senior judges as of last Wednesday. And one of those was in my circuit because the chief judge at that time who got assigned the death penalty case was only about 9 months away from retirement, didn't want to burden a new judge with the case and didn't want to have to reassign the case, was able to talk a senior judge into taking the case. As I understand,
Judge Smith or
Judge Smith, yes, it's Bill Smith out of Columbus. So a polling of our senior judges, that most of them don't particularly care to handle death penalty cases anyway, that they see no problem with it. We did want to clarify the language that as it is, the language says in a any criminal case involving a capital offense for which the death penalty may be imposed, that's any murder case, the death penalty may be imposed. We wanted to add in which the district attorney has filed a notice of intent to seek the death penalty in accordance with the Unified Appeals Procedure. This language has also been communicated to Representative Fleming's office through one of his legal assistants, and I don't think there's any particular objection to it. We just want to make sure it's clarified that's only a death penalty case.
Let me have that language again, just make sure I have it correct. After the word imposed on line 28, I'm thinking that you would lose the period there probably, and then insert "and in which the district attorney
Has filed a notice of intent to seek the death penalty.
has filed a notice of intent."
Probably ought to run it by Representative Levitas, his mother being a school teacher. That
As long as there are not any commas in it, you're probably all right. Yes.
and that would need to go in all three sections.
All right, and that's to seek the death penalty pursuant to the code.
Well,
section.
I had
thought you
added
to
in
say that.
accordance to or pursuant with the Unified Appeals Procedure. You don't really have to add that.
All
I
right.
think it's clarified sufficiently with the notice of intent to seek the death penalty.
Okay. Yes, ma'am.
I just want to point out that part of the difficulty with trying to structure this and for consideration of the committee is that when do you change judges? And the way this is written is kind of the beginning. And the way that this new language would be in the middle. And that's fine, but that's all.
Well, I'm not sure I follow what you're saying. Maybe I'm just slow.
The defendant is arrested for murder.
Mhm.
We're in the beginning stages. Superior Court judges assigned to the case.
Mhm.
There's some circumstances in which they decide as a senior judge that they want to have family in the case. And 4 months down the road, the district attorney, they've heard some issues on the case, but now the district attorney decides to seek the death penalty. Now you change judges. That's fine.
Well, that is a bit of a problem because it might give the district attorney an opportunity to shop for another judge if he doesn't like the senior judge.
Well, practically speaking, this is not the way it works.
Yeah, I'll let you answer it. Go ahead.
If I may address it, and I'm not an expert on all the way courts work throughout the state. I am to the extent that I speak with other judges every chance I get. But the bottom line is we have an innate feeling for when a case is going to reach that death penalty issue. The district attorney may not seek it in every case that we think, but we have a good gut feeling at the beginning. And most judges I know will not hand off a murder case to a senior judge that may very well end up being a death penalty case. It's just not going to happen very often. And if it does, it's everything you do before the Unified Appeal Procedure kicks in is minimal at best compared to what you have to do under the Unified Appeal Procedure.
All right. Did you have any other comments?
Other than that, I want to do what everybody else has done. I think y'all have done an excellent job working on this. This is what you do when you have a major rewrite, a bill that came out and took effect in 2005, right as I became involved in the Council of Superior Court Judges. And you're going to have things like this that need to be cleaned up, and I think it's been addressed. There are issues that are being discussed, and I respect this body, and I certainly also want to commend Matt Crawford for the job he's done. He's been in touch with all the judges in this state, all the Superior Court judges, especially those who have death penalty cases pending, and has been working with them daily. And I just appreciate his hard work, and I think with the rewrite that's going to come out of this committee and through the House and Senate that it'll be a better bill.
Thank you very much.
Mr. Chairman, could I be heard?
Certainly.
I think Judge McGarity was at some of our meetings, but I want to, while he's here today, on behalf of the council, tell him how much I appreciate the input that Judge Lawton Stevens, who was on the committee, and Judge George Piegler from Sumter County?
Yes.
Yeah. We're excellent members and very active members of our study committee, and they're not here today, but I want to say an appreciation to the council for having them serve. They did great work.
Thank you. Thank you, Judge McGarity. I've got Don Oliver and Michael Edwards. Does that mean, are they still here? You are. Okay. Is Michael Edwards here also? All right. Y'all come around. just come up here, try and find an extra chair to bring it around there.
How are you? Good to see you. If Don Samuel's still in the room, we can have a class reunion of our law school class up here.
I wanted to save the brain for last.
Oliver and I wouldn't disagree with that, would we?
No doubt about that.
I wouldn't be a part of that class. Respectfully.
Ladies and gentlemen of the Judiciary Committee, thank you for the opportunity to be here. As a former member of this committee, I've spent many hours down here. One time I thought I should just have a cot here, so it's good to be home. I'm the newest member of the Georgia Public Defender Standards Council, and I guess they see me as a pledge, and this is part of the hazing that I be here and represent the council today. But I consider it an honor, and thank you. I want to also commend the committee for doing a great job. There were a lot of issues that needed to be addressed here, and the Georgia Public Defender Standards Council agrees with the committee on almost all of the provisions of this bill, and have in fact adopted recommendations for such legislation and approve most of the things that have been recommended. There are just a few areas where the committee might want to consider a little bit of tweaking. This has been mentioned several times. One of those areas is the reducing from the availability of a 4-year term to mandating a 2-year term. One of the hallmarks of the majority's position over the years has been to leave as much as possible to local control, and I think as much as anything, this goes to that issue. The local folks should be able to decide what term they want their circuit public defender to have. Presently, it's a maximum of 4 years. If they want to decide 2 years, they can decide 2 years. If they want to decide 1 year, they can. And I think it's a mistake to take away that local control, because they're the folks on the ground and understand what's needed. So that's one area where we would disagree, and we feel we should leave it like it is, where you can go up to 4 years and anything in between.
Would that require anything other than just changing the numeral, what you're suggesting?
Just removing the new language, basically. It presently says up to 4 years, and the new language just specifies it to max of 2. And so that's that is in section 26. Section 28, dealing with the 72-hour rule. It's kind of difficult to state a position here, because we're like a lot of other people. The present law is a little vague, and there's no real direction as to what has to be done. I think the new proposal is kind of vague, and there's no real direction as to what has to be done. I think Representative Benefield had some really good ideas. When I served in this room with Representative Groover and others, we were always very wont to let anything out of here that we didn't think was perfect as far as we could determine. In this particular instance, I think once this crosses to the other side of the Capitol, there's little doubt this one's going to end up in a conference committee, and breaking from what I see as good committee work, maybe letting this one go on like it is, and between now and conference committee, Representative Benefield, the circuit public defenders, maybe the defense bar could really take a hard look at this section and come up with something that's actually more functional in relation to practice at the local level. And I'm speaking now as a county official, not for the Georgia Public Defender Standards Council. Anything that increases the time between a defendant being seen by a public defender or an attorney works to the detriment of county governments, because one of the major expenses that we face that we can't really budget for is medical expenses from inmates. And all it takes is one major medical problem on an inmate that hadn't gotten out on bond yet, and any savings that we might pick at here and there are blown out the window. And so I think that the circuit public defenders are presently doing a good job of getting in there and qualifying the people. And so one of the stated reasons for changing the rules was with the counties coming on as qualifying agents, it might work better. Well, I can tell you the counties are not coming on as qualifying agents. None of us are going to touch this with a 10-foot pole. This money that we might could collect, it's just there are very few defendants slipping through the cracks on this qualifying issue. You'll hear an anecdotal case now and then of the guy who has got a circuit public defender, but he's got the big house and the swimming pool and 4 Cadillacs, and mostly that's all. It is just anecdotal evidence, but again, it doesn't matter what his assets are. The legislation talks about income. He can have all this stuff, and it doesn't matter. We're looking at income, and I think these guys are doing a good job. But anyway, I think as we get into conference, I think we should take a look at something that will be more practical and definite in the long haul. On page 26, section 26, line 25 and 26. And again, I'm stepping out of the authority I've been given here by the council and speaking for myself. This was in this language right at the tail end of line 25, where they're talking about a replacement if a circuit public defender has to be replaced to serve out the unexpired term of office. I think that clause right there needs to be removed, because
he'd have a new term off.
You have an interim being appointed until the selection committee can meet and consider the new circuit public defender, and it's going to be really tough to get somebody just to fill out. You're going to be entering into a new contract, so let's not limit this local selection committee to only hiring the person to go out, finish out the term, but just to hire the new person, enter into a new contract, and be done with it. So I would recommend that be cut out. And I think that's about incredibly for a bill of this size and a bunch of lawyers together. We don't have any more disagreements than that. So they've just done a fabulous job, and I want to commend the chairman and the committee.
Thank you very much, Mr. Edwards.
Thank you. I'm Michael Edwards. I'm the Circuit Public Defender for the Eastern Judicial Circuit, which consists of Chatham County. It is one of the few single county circuits in the state, and one of even fewer single county circuits that participate in the system. I'm here today as past president of the Georgia Association of Circuit Public Defenders, and it's already been commented, there is a great deal in this bill, of course. It is an omnibus bill, and there are issues about which I suppose somebody could have a comment about virtually every one. Petition, I'll keep that to a minimum, is just speak about just a few things that as an association, the vast majority of the circuit public defenders have endorsed as either a concern or in support. And beforehand, I would just also like to echo all the comments commending the committee for the hard work. We were up here for many of those meetings, and I know how very, very hard the committee worked in trying to come up with some solutions to the concerns that were expressed. I think it would be fair to say that probably the three greatest concerns that have been brought to my attention by the body of circuit public defenders have all been addressed and discussed quite extensively already, and I just want to just share just a couple of brief thoughts on that. The first is the change of the term, and I think that that's been discussed rather exhaustively, but I would just absolutely encourage this body to really give consideration to those comments. It would be exceedingly difficult. We listened to quite a lot of comments by various different members of the study committee expressing the desire to have not only strong advocates in the positions of circuit public defender, but also good managers. And I think we CPDs share that feeling very much. As the system matures, that becomes even more important. And it would just be very, very difficult to have that expectation reach a reality if we had the limitation of the terms from 4 to 2. That ties into to sort of a larger picture that Mr. Oliver mentions, and I would also just encourage, with respect to Section 26, with the proposed adjustments to the currently existing selection panels to convert those to a supervisory panel and to expand their number. We have spoken a great deal with the ACCG about this issue, and we don't. I'm sorry. Well, the section is 26, and its page is 24 through 26, and my comment on that section in its entirety is simply this: that I would encourage, as was alluded to earlier, I would encourage as much local control to be retained in the functioning of those supervisory panels, so that the members of the supervisory panel make the determinations about the necessity in meeting and the frequency with which they feel it important to meet. I have spoken personally with some of the selection panel in the Eastern Judicial Circuit, and I know that their expectations may not be to be in a position where they're meeting by compulsion 2 or 3 times a year. They would certainly, I know, meet as necessary, but I would just, it's not a specific recommendation, but more of an idea that I think that we need to try to bear in mind in keeping with ensuring that the supervisory panels reflect the will of the local community to maintain as much local control in the functioning of those supervisory panels as is possible. The second issue, again, that has been discussed quite a lot is the 72-hour discussion. It is just, it is so critical that the folks that are going into the jail are able to have the services of counsel at the earliest opportunity. And I think Representative Benefield's comments about the condition, if you will, of so many folks that are coming into the county jails is just dead on correct. We have so many folks that are coming through with mental health issues, with diminished intellectual capacity issues, with addiction issues that are in the throes of that as they come into the jail, and placing on them the onus of doing something that just by the discussion here is quite clearly less than simple, I think is a very worrisome and troubling concept. And I also do know that my experiences with judges, not only in my circuit but throughout the state, is that it's very important to them that individuals be represented as rapidly as possible, as is the case with the sheriffs. I think that comment was previously made too. The longer folks are without counsel, the greater the burden, frankly, that the county faces, or certainly potentially faces. And then the third issue I would like just to also highlight is the indigency question, specifically with respect to juvenile offenders. I think that there is I think that there is a consideration to bear in mind dealing with the juveniles versus the adult defendant, just in terms of the heightened need for any degree of guidance, certainly legal guidance, but the heightened degree of guidance and assistance that a juvenile defendant needs just by virtue of the level of immaturity, by virtue of the lack of other guidance that we certainly hope is being received, but oftentimes is not being received domestically, and oftentimes even, unfortunately, in the school system. So I do think it's worth considering that juvenile applications all be considered, irrespective of the nature of the offense, with that in mind. As I mentioned, there are quite a number of circuit public defenders in the state of Georgia, and many of them have their own experiences in their own circuits. They have their own peculiarities within the operation of their system, and I know that I'm certain that many others would have comments or thoughts about specific issues, but I think that those are really the issues upon which we all are experiencing the same sorts of general problems or concerns or successes, and we would ask those to be considered. And I will just say, with respect to the issue of getting qualified folks in the position, I appreciate Representative Collins and the chairman's discussion about the salary issue, and I do recognize that this is perhaps not the place to do that, but I do appreciate the fact that it is recognized that having that managerial experience accompanying that the degree of advocacy is very, very important. There are a lot of considerations in ensuring that we're getting those folks to the table, and I thank you for giving me the opportunity to speak on those issues.
All right, any questions from the committee for either of these gentlemen? Not, thank you very much. I'm sorry.
To Mr. Edwards, you just raised a question for me regarding juveniles. Is there any compulsion for parents to provide legal counsel for their children should they be arrested? I mean, could a parent opt to not provide legal counsel if the child so desires?
Within the act or otherwise
outside of the act?
I don't think that the parent has the right to prohibit the juvenile from having a lawyer.
No. Does the parent have the obligation to provide? So let's say that you have a juvenile who's at 100% or 125%, so given the proposed state of the law, if the juvenile was at 125% of the poverty level, and it was a misdemeanor, and therefore would no longer qualify for indigency under the statute, would the parent be obligated to provide legal counsel? What would happen to that juvenile if they don't qualify under this law?
One of the things that happened with the act initially was the obligation that all of our offices create a juvenile division, and at the sake of some sacrifices in the superior courts, we all did that, and I did that, and I ceded that responsibility to Mark Nathan, who is our chief juvenile defender, who is excellent. He would really be better to answer the question, and I say that only because I'm going to tell you I think the answer to that question is the focus is upon the child, and I do not think that the parent has an obligation to provide representation that would keep the child from having the ability to secure counsel under the act.
So I guess my question is sort of the opposite. Is there a scenario under which a child, because they don't qualify for indigency under the statute, is there a situation where that child would not receive representation?
I think that that would occur.
Okay, thank you.
Any others? All right, thank you. Mr. Wynn, do you have any comments you want to make on this bill on behalf of the district attorneys? Two after Mr. Wynn. Yes, sir.
I'll just state, Mr. Chairman, thanks for the opportunity that the district attorneys join in the desire to have criminal defendants receive adequate, competent counsel and constitutional defense. The only thing that I would come in on as far as this bill goes is that I think requiring a defendant to request counsel is a good idea, and the Supreme Court has held that that's the defendant's right. The right to counsel is a personal right of the defendant and not of the attorney. Defendants still retain the right in this country to represent themselves if they so choose. So I think that the effort that the committee has put forth to put the onus on the defendant to request counsel is actually very good and constitutional procedure, but I do commend the committee as well for their hard work.
Thank you very much. Yes, ma'am.
quick question. Do you have a particular case you can cite on the onus is on the defendant is the defendant to, it's their right to request the counsel, not the attorney?
Representative Phil, that's a U.S. Supreme Court case, and I can't off the top of my head recall that case. I just had to deal with that issue in a death penalty case. But I don't recall the case name offhand. I'll be glad to get that to you.
Okay. I appreciate it. Thank you.
Mr. Ed Garland.
Thank you, everyone. I'm Ed Garland. I'm a lawyer here in Atlanta. I've been practicing over 42 years, done a lot of criminal defense, been actively engaged in the effort to see the creation of the system that was so well created by the work of the legislature some years ago now. I am here as a board member of the Southern Center for Human Rights, and we have a position paper that may I
certainly
pass it out.
Just throw it over here. We'll get them out. Thank you.
Concerning the issues, most of which have been talked about here today. Our first position is that we think you should leave the 72-hour procedure exactly like it is and not change it on the basis that this system is working, it is efficient, and should be preserved. Or in other words, it's not broken when it comes to the 72 hours. When you start changing it, you create expense. And as it is proposed to be changed, it's unclear as to how it will be implemented, the new system. The public defenders don't want more business. They're not over there soliciting that business. They don't want to qualify any more of them than they have to. But law enforcement benefits when a lawyer, in fact, is brought into this system. Because when the lawyer comes in, if the guy has said, I want a lawyer, the lawyer gets there and the guy wants to make a deal and provide information. Previously, he has said to the police, I don't want to talk to you. I want my lawyer. At that moment, often the faster you get counsel in, the faster he cuts a deal with the police to deal with it, provides information, it leads to other arrests, and he's represented, becomes a witness for the state. Very often, that is what happens when you know that most of these cases are disposed of by guilty pleas, 90-something%. So getting the lawyer in fast and quickly really makes a lot of sense. And it's cost efficient. It's going to cost more if you change it this way. You're going to have some new people occupying this role of getting this done. And it costs more the longer these people stay in jail. Get them on out of there. You get them to the bond hearing. The rule's 48 and 72 hours. Well, you don't want them going to a hearing without a lawyer. Because the fundamental principle is that it's morally and constitutionally required that if you're indigent, you be provided counsel if you can't afford one. And everyone that is approached by these lawyers ask to have counsel. So we urge you not to change the 72-hour rule, leave it like it is, and don't go with the proposed change. On the issue of maintaining guidelines for eligibility, I just want to say something about that in the big picture. In the big picture, you're either indigent or you're not indigent. The nature of the crime doesn't affect whether you're indigent. And the duty to provide counsel is mandatory under the Constitution. So just for the larger picture, if you really want to think about it, making distinctions between misdemeanors and felonies has no real basis. You say somebody's got to be more indigent, and in this situation, the standard being set is so low, I would call it the starvation standard. That somebody in the family has to be going without food to qualify. And the law doesn't, if you can't pay for a lawyer, you might have some assets, you might have spent your money, you might have made some money, but you get arrested, you lose your job, you lose your bank credit, you lose everything you have. So the miserliness of that, I don't want to make any bigger issue out of it, but if you step back and look at the perspective, to get the peach care, it's something like 250% more or less. See, to get the federal poverty guideline for eligibility for peach care, it's 235% more than the federal poverty guideline. So I would say if you really want to clean it up, just the standard should be, can they afford a lawyer? But to say that about the issues we're really concerned about is that maintaining that 4-year term is essential. Who in the world would want to do this kind of work without knowing, at least I've got a job for 4 years? Because the truth is, this is the hardest work. It is work that people do not receive praise for particularly. You're dealing with the most difficult human beings possible under super stressful circumstances, and you're making de minimis income. The right to counsel protects the innocent as well as people who are guilty, just like the presumption of innocence. I urge y'all to take it very seriously that, boy, we need good defenders, just like the young man, Mr. Edwards, who just spoke. You could just tell what a good job somebody like that's doing to look after the citizens. So give them at least 4 years, for sure. And then finally, I know this business of the $50, upping it to $100 is in here. But I'd ask you to think about it in realistic terms. You're talking about indigent people and making indigent people who can't afford to pay for the system. Doesn't make sense from an overall perspective as I see it. What has to happen in this state is we have to pay for justice. And we don't pay for justice. You have to pay for justice with whether it's paying more to the police, more to the prosecutors, and more to the judges, and more to the public defenders. So the state needs to assume the responsibility and provide adequate funds, because it will be a lot more expensive if it's not done. And I've heard the comments about, well, the system may go out. And with all due respect, I was one of the lawyers, along with Steve Bright, that brought the lawsuits suing. And if the state doesn't do it, it's going to be a lot more expensive. The state's going to wind up under the jurisdiction of the federal courts. You're going to have all kind of lawsuits, damages, and everything else. The cheapest thing is to provide good lawyers, to provide them right away, and get the system moving. And what happens is you get them there in the 72 hours, they get through the system, and you don't have delayed justice. The cases are over, they're moved on. In Fulton County, they have a complaint room, and you go there, and 90% of the cases are disposed of the first couple of weeks with pleas or other things. So it's made a great deal of difference. Thank you for hearing from me.
I think you've drawn a question from Mr. Representative Levitas.
Thank you, Mr. Chairman. What's your idea of adequate funding, system-wide or per individual? What is adequate?
Well, I didn't come here to address that. I'm not an expert on it. I do know that in, I believe it's North Carolina, their system is about 6 times as much to provide the same amount of services. Maybe it's 5 times, $17, $18 million. And at some point, somebody's got to step up and say, let's just fund it right, have a first-class system that we're proud of. If this thing gets rejected, what we're trying to avoid is just what we started litigating about. People were languishing in jail. So you start changing, letting lawyers get in there and get them a lawyer, you're going to have them lost in the system. That's when everybody's going to become liable and the system's going to collapse. So why not really do it right?
Well,
why do it so poorly? And
well,
the number is, I'm sure that the council and others can come up with what really is an adequate number, but we're nowhere near it. And this whole idea of cutting it back is a shame. I mean, people should be ashamed if they start trimming and destroying the system that has barely gotten off its feet. And that's really what's going on. If you want to do something really great for this state, fund this system right like other states have done, where people can be proud of it. You know, you just had a decision yesterday, I think it was, in the Supreme Court of Georgia. All 9 judges have put more financial burden on the system. What's going to happen is the judicial branch is going to ultimately say, either pay it or go to jail. Somebody. I don't know if it's the treasurer or who else, but at some point somebody will have the courage to say that there is no issue. You have to do it. The Supreme Court of the United States has said you have to do it. It's not an option you have.
Well, I agree. I agree with you and I don't think there's anybody in here, or at least I've never heard anybody say we want to provide an inadequate defense for indigent defendants. I know that's not my view. I don't know of anybody on this committee. It certainly wasn't the view of the people who spent the summer studying this. So I think sometimes the devil's in the details on these issues. And as the question is North Carolina enough for you? Would it be if we doubled that budget? So I guess what we have to deal with here, and whether it's indigent defense, whether it's water crisis, health care, whatever it is, there are lots of first-class systems that you can provide. And there's lots of ways to do that. And you could keep taxing people until we reached the point where we thought we had enough money to provide an adequate system. But just to say, do it right, do it first class, there's a big disconnect for me between that and coming up with the dollars to do it and what you may think is a first class system, what I think is a first class system. And I'm suggesting to you that just to throw out there and say you guys are trying to destroy the system by doing this, to me, doesn't really advance the debate very much. So the question becomes, if you have specific problems with the standards and the money, what is it specifically? Not North Carolina does it this way, because I don't know their system either. I don't know how many people they're treating, what their view of what a quote-unquote adequate defense is, how their systems work, or whether that's a very inefficient system that's funded with a lot of money. So what I'm asking you for is give me or give the committee some idea of where the rubber meets the road for you beyond we need to provide a system. And again, there's a difference to me between a first-class system for indigent defendants and the kind of first-class idea of up here, we're going to make sure they have every expert witness available to them, where they're going to have every opportunity. So I'm asking you, do you have any specifics in mind where it's deficient specifically and where you think that here's what you need to do to get it to my idea or somebody else's idea of what a quote-unquote first-class system is, and how much would that cost?
Well, I would be glad to come back and do that. The issues we addressed didn't deal with money, given what we saw the jurisdiction of the committee. And my response goes to the general idea that I have been hearing about the funds are being cut and difficulty getting the funds and not being able to pay for things. I was just making a general comment. But I agree with you there. If it is approached that way, what does it really take? And the legislature goes back to what we thought was the position when it was created, that we're going to fund. A great system was set up, and this work to make it better is good. Somebody's got to address that issue, and I didn't come to address it. But I certainly think it is a great deal more, at least twice what has been previously allocated. And if you take a hard look and say you want a real answer. What makes it adequate? A system that, in fact, provides counsel. You're going to find it's one that the whole discussion is one of narrowness and one of nickel and dimes in something where you need some real bucks to have a good system.
Okay. Thank you, Mr. Chairman.
Thank you. All right.
Thank you very much.
Thank you. I don't see any other questions. Call on Mr. Don Samuels.
Thank you, Mr. Chairman. I'll be brief, and I don't mean to pile on some of the same provisions, but I also want to focus primarily on Section 28, page 27, and particularly page 28 of the bill dealing with the 72-hour rule. It obviously is something that has caught everybody's attention in the defense bar. That's why so many of us are here speaking about that. I believe that the genesis of this bill originally, not the amendment today, not the bill being brought to you today, but the genesis of having the 72-hour rule was to ensure that people are not languishing in jails, as everybody has said. And there were cases, particularly in some of the rural counties, where people were going to jail and spending weeks or months there until their arraignment. That was the first time any judge ever said, you have the right to a lawyer. Do you want a lawyer? Yes, I want a lawyer. And literally weeks or months, there were people sitting in jail waiting for a lawyer. And the whole point of the bill originally, 3 or 4 years ago, was let's get a lawyer in there fast and see if we can deal with the person and resolve it. So many of these cases, as everybody says, resolve right away. In Fulton County, they're getting them into the complaint room. They have a lawyer, and out the door they go. The case is resolved. They can even plead cases within a matter of weeks in Fulton County now. And to try to slow that process down now is antithetical, it seems to me, to the whole point of what the legislation was designed to do several years ago when it was initially passed. The way the law works now, obviously there's some differences in every county, but basically the public defenders go to the jails, they meet with the people, and they try to figure out if they're eligible. They make an initial eligibility determination and then represent them at their first appearance and at their bond hearing. The way this bill works, let me just tell you some of the questions that just seem to arise and without any answers at all. There's no explanation of how a defendant in jail is to make a request for counsel, whether it says Representative Setzler, who was here before, said it's the invocation of your Miranda rights. Is that actually what this bill is designed to do, to say if you invoke your Miranda rights, then you can get a lawyer, that triggers the 72-hour period? Whether it's a form that has to be filled out that's devised by various sheriff's departments around the state, whether it's a request to a police officer on the way to the jail, you're in the back of a police car and you say, I want a lawyer, does that trigger the 72 hours? There's simply nothing in this bill at all that talks about how to trigger the 72-hour period. With all due respect to my colleague, Mr. Wynn, he's not right. You do not have to request a lawyer in this country. The default in this country is you get a lawyer. You are appointed a lawyer. You have to take affirmative steps to not have a lawyer when you go to court. The decision, of course, is Feretta versus California, which says if you go out of your way and affirmatively demand not to have a lawyer and waive your rights to a lawyer, then you can, in fact, go without a lawyer. But the default is not that you have to request a lawyer in order to have a lawyer.
What's that case again?
Feretta versus California, for F-A-R-E-T-T-A. And it talks about the steps that you have, the affirmative steps you need to take not to have a lawyer. Now, of course, that's in the trial setting, U.S. Supreme Court, right? So the default is you should have a lawyer. And what this bill accomplishes is it slows the process down, which is exactly what we don't want to happen. That's really the most important thing I have to raise, the 72-hour bill. I would strongly urge you to go back to where you were, go back to the way the bill was, which provided very simply the public defender goes there, they meet with the client, they determine eligibility and represent them as soon as possible, and not tinker with that. That simply wasn't broken in any way. Thank you.
Thank you, Mr. Samuel. You did draw some questions. You want to take them?
Yes, absolutely. I'm sorry.
One of them may have been Ms. Benefield. Ms. Benefield, did you have a question, or was it Mr. Levitas? I'm sorry.
I had a question. I don't know
All
if
right,
you
Mr.
did.
Levitas.
When we talk about getting contact within the 72 hours, just for the purposes, let's assume that we had that system. would you be satisfied, and I know you can't speak for all criminal defense attorneys, I'm not asking you, but based on your experience, if personal contact is by telephone, because some public defenders cover 6 counties, for example, and a face-to-face meeting in 72 hours is completely unrealistic, in my judgment, or once again, the state has passed down unfunded mandates to the county and required them to do something without giving them funds, and we make a whole sub-practice out of doing that here. Would you say that it would satisfy your understanding of the constitutional requirements for representation if that was done by telephone as opposed to in person?
Yeah, let me make sure you understand the 2 problems with this bill. One is what is triggering.
I understand, and I'm not asking you about that. I understand that.
So if we don't have that triggering mechanism where the defendant has to know somehow, either through a Miranda warning or TV, as Representative Setzler said, or something, he has to trigger this process. If you get rid of that, then, the 72-hour period, whether it's by telephone or not, I don't think that's a huge difference. Obviously, it would be much better if on a regular basis the public defenders or representatives from their office, which is the way the bill currently works, goes to the jail, finds out who's been arrested and who is eligible. I strongly disagree that public defenders are out there shopping for cases. I mean, they are not. I have never heard public defenders do anything except complain about how many cases they have. They are not going to the jails and saying, gosh, I wonder if I can find some more cases today. That's what we do. That's what the private bar does, because that's how we make money. That's how I put my kids to school. I fish for business. But the public defenders, I mean, it's the last thing on earth they do is go and try to get more cases so they can be,
Right, that's not really what I'm asking
but
you.
But to answer your question directly, I think it's fine. If there's some kind of contact made so the person knows he has a lawyer, and so the lawyer, whether it's through an initial telephone contact or in person, knows what to do to get that person some help. Get him to a police officer, if that's what's needed to try to resolve the case. Get him to mental health, talk to the sheriff, get a bond worked out with the DA. Something to keep the process moving. You don't want these people languishing in jail. It doesn't help law enforcement. It doesn't help the sheriff's department. It doesn't help the DA's office. Nobody wants people sitting in jail without.
And you've led me to my next question. This is my last one, Mr. Chairman. I assume that you don't have any of those problems if the person has bonded out. None of these requirements really would matter for that because no one's languishing at that point, including verification of indigency and all that other stuff.
I mean,
Okay.
At some point, you start losing rights, even once you're out on bond. You can't cooperate with the police. You want to get people to lawyers, but the urgency of the 72 hours. And in fact, the bill says it starts with incarceration or process, meaning I think indictment is what it means by that. But if the person makes bond the day
it actually says notice.
Well, it's
charge, petition, notice, or other initiation process.
I think it's a summons.
I don't know what that means.
I don't know what it meant originally either. Maybe Chairman Ralston could tell me, but my understanding was either an indictment or summons to appear in court, a ticket.
But if they're not in
UCC.
jail, these concerns are not. Your concerns are related specifically to people, as you say, languishing in jail.
Absolutely.
Okay.
That's clearly the most paramount problem: is the people in jail who have nobody.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you. I know the hour is late, but I want to ask you a question. Hold it. I want to ask you a question. And I know we have the public defender from the Rockdale Judicial Circuit here. I'm trying to speed this up, so I'm not going to ask the question directly to him. But aren't there from time to time people who might call up the public defender's office and say, the sheriff's department's been out here and told me they got a warrant for me, and that they want to talk to somebody? Or how are those cases handled, and how would they be handled under this language that's proposed in this bill?
Did you want me to answer?
Yeah, I'm asking you.
That's a problem that happens in the federal system as well, because even the federal defenders aren't allowed to take a case until there is a case. Mm-hmm. So it happens with grand jury subpoenas.
Well, I mean,
example.
there may be a
Somebody
warrant.
gets subpoenaed to be a witness.
Here's my point. There may be a warrant. Let's say they came out here and they tried to serve a warrant at my mama's house, and I wasn't home. Yeah. So there's a warrant. Is that notice under this?
I don't know how it's being interpreted, Mr. Chairman, but I can tell you I think those people probably are not entitled at that point to a public defender. I don't think under any construction of the Sixth Amendment or the
even if they want to come into the office and
they don't have a right to a lawyer. I'm not saying that they can't hire a lawyer if they don't want one, but they do not have a right to appointed counsel if there's nothing pending.
And a warrant doesn't make it pinned?
No, sir.
Okay. All right, I'm going to recognize Mr. Collins, who just left.
It was not.
Oh. Mr. Collins, did you have a motion or two?
Yes, I did, Mr. Chairman. Thank you.
Yes.
I have two amendments. The first amendment in two parts. Page 25, line 30. All right, thank you. Page 25, line 30.
Yes. I apologize.
I apologize. Go ahead. My
I'm
bad.
going to have to rule you out of order. I've been corrected. You're absolutely correct. What's the will of the committee?
You know, but you pass a motion on the floor before you can entertain amendments. So for the purpose of entertaining amendments, I move to pass.
All right, is there a second? All right, we have a motion and a second on the floor. I'll recognize Mr. Collins to continue with his proposed amendments.
Thank you, Mr. Chairman. Thank you
for
for the
correcting
procedure. Thank you on that. All right, page 25, line 30. At the end of the line, strike 2 and replace with 4.
Is there an objection to that amendment from the author?
I object.
There's an objection. All right. We'll go ahead and take this one up then.
Okay.
Is there any discussion on this amendment? Further discussion?
Yes, I believe that. What page are we on again?
I think that's in there one other place.
In one other place.
I think the way to fix it would just be to remove all the language, the new language found on lines 28 through 32. Just remove all of that and keep the code to read as it currently reads. That's my, and if for what you're trying to accomplish, I happen to agree with you. If you want to keep it the 4 years, you just take all that new language out. No? Okay.
You can take out lines 30 through the end of 30 lines, the underscored language on line 28, 29, and 30. The sentence on line 31 and 32 was probably language that was intended to be in the original act, allowing public defenders to succeed themselves. That wasn't in there. So those are two different things.
Okay, where's the other? Because I was looking through, and I mean, I probably missed it on run through. Where's the other language that?
Line 28 is where we talk about 4 years on 2 locations in current law. In
Okay.
terms of up to 4 years.
Right.
The initial appointment shall be for terms of up to 4 years.
So would you say the best? Because I remember, Mr. Chair, you said it was in the bill somewhere else as well, and I didn't see it, so I wasn't sure. That's why.
There is the on the following page. There's the part about the unexpired term, but I don't think that has.
Well, that's another amendment I was waiting to make.
Okay.
So,
all right.
At this point, I mean, if it's better for Ms. Travis, if it's better for purposes of language there to just strike that sentence starting at on one page, line 28, at the period, 4 years period, and strike from any circuit to the next period, then if that's easier language, I'll just do it that way. I'll amend my motion. Okay, I'll make the motion in that form then.
All right. We have a motion and second on amendment. We have an objection to the amendment. Is that correct? You still persist in your objection?
Yes.
Do you not? All right. Any further discussion? Seeing none. All right. Seeing none. All those in favor of Representative Collins' amendment, please say aye.
Aye.
Those opposed? Aye. Thank you. I was supposed to say nay, wasn't it? All right, I believe the ayes have it on that, so I'm going to rule that is an amendment that will be made.
Okay, Mr. Chairman, may I continue?
Yes,
I have
please do.
I have the second part of this one and then one more amendment.
All right.
The second part of this amendment is page 26, line 25. Place a period after replacement and strike to the period.
Second.
All right. Is there any objection to that proposed amendment? Any objection? Hear no objection. That amendment is adopted.
Okay. Thank you, Mr. Chairman. My last amendment, this has been worked on with council and also discussed with others. It goes to section 28. The amendment will begin after the period. of this code section, period. The amendment will begin there.
He's on line 3.
Line 3.
on
I apologize.
page
Line
28.
3, page 28. This is also section. It's just page 28. It's easiest to get to. Page 28, line 3, the period in the middle.
After the words code section,
Page
there's a
28,
period.
Tom. Page 28. Okay, are we? All right, and is it the next line? The next one, the word would have been in order.
I didn't get. What was it?
Page 28.
Page 28,
Okay.
line 3.
Line 3. What about line 3?
That's where I'm trying to make my amendment
Okay.
at this point. The wording will start at that the new language added, stating within 72 hours of a person being taken into custody, an employee of any programs established pursuant to Code Section 17-12-80, if such program is established, or if no such program exists, an employee of the Circuit Public Defender's Office shall notify the person of the availability of the Public Defender Service and make an initial determination of the person's eligibility for representation, period. Then go to line number, I have to get a line 3. Start. Then we'll pick back up within order. Is this correct, Joe? Okay, pick back up within order. Go to line 6. No, we're going to need to go to line number 8 or 7. 7 at the semicolon. 7 at the semicolon. Oh, I'm sorry. Provided, however, then the new language would read, a public defender shall be appointed for any indigent person prior to any court appearance for bail hearing or preliminary hearing. Period.
All right. Is there any discussion of, well, I guess, is there any objection to that amendment? Substitute motion. I think takes priority. All right. Substitute motion. Yeah, I saw. Go ahead.
It's okay.
You got me baffled.
It's quite all right. No, while I appreciate what Mr. Collins wants to do, I'd like to take an attempt at a preferred approach first, and if it fails, then we return to the original motion. I would instead like to strike lines on page 28, strike in its entirety, beginning at line 1 through line 9, and to reinsert in its entirety page 27, lines 34 through 36, and line 1 on page 28 to the period after process. So essentially to return the law to its current state.
Second.
She's trying to return it.
All right. There's been a successor motion and a second. All right. Are there any other amendments that are being proposed on this, a successor to Mr. Collins' amendment? Mr. Levitas.
Discussion on me.
Yes.
My only concern is, and I don't know if this is, I think it's unaffected by Representative Abrams, is right now there's no requirement for the public defenders to be a magistrate court, and I think we would be putting one of those unfunded mandates I was talking about. If we add that amendment, we would then be imposing another cost on the county that's unfunded because they don't appear in magistrate court right now.
If I can respond, this bill does not add magistrate court. I'm only returning as to the current state of the law, which does not have that requirement.
So this would take out that language then, that
Correct.
Representative Collins. Okay.
My substitute
Okay.
motion is that we simply return to existing law.
Why don't you read it? As
So
it would read
it would be line 34
on page 27.
on page 27. in each of the actions and proceedings enumerated in subsection A of this code section, entitlement to the services of counsel begins as soon as is feasible and no more than 72 hours after the indigent person is taken into custody or services made upon him or her of the charge, petition, notice, or other initiating process. My rationale for this is that, according to the testimony we've heard from all of the persons involved, this situation is the current status of the process is working, and there is no objection from the Public Defender's Office to the existing state of the law, and so I would respectfully suggest that there's no need to change the process.
All right. I think everyone understands the amendment. Any further discussion? Is the amendment agreed to? There is an objection to the amendment. Mr. Knox, you had your button.
I waive.
Right.
I'm sorry, tell me, what are we on?
We're on the Abrams amendment. There has been an amendment and second. It has been objected to, so it is not agreed to. Any further discussion? Seeing no further discussion, all those in favor of the Abrams amendment, please raise your right hand.
Will you cut my mic?
Yeah, you want it on?
Sorry? What are we doing?
We're voting on the Abrams amendment.
Abrams amendment.
And if you are voting in favor of it,
I'm not.
what was the vote? How many are opposed?
Yes,
4 to 5, so that amendment fails.
Chill.
All right. Next amendment. That would be the Collins amendment. Everybody understand the Collins amendment? Any further discussion? All those.
I don't understand it.
All right. I'll ask Mr. Collins to explain it one more time.
Okay. This is taking back into account the 72 hours person being taken into custody. The bill itself, is my understanding, Mr. Chairman, is if it's wrong, is I know in my county the way it's set up is there is a separate office that actually, and the reason for the language pursuant to code section whatever, there's a separate language that there's already someone set up that does the indigent intake, basically, that is separate from the public defender's office. And this is also the language of the money issue, the 50%. Is that not correct, Mr. Chairman? If they set one up, if they don't have one now, they get 50%. If they do set one up, they get 100%. Or the way that's they set one up, they get 50. They don't get anything. Okay, I had to all right. I same idea, just wrong way. At this point, making the eligibility, which gets in, then we leave the language in as the current language has it, and basically it just reinserts a 72-hour window in here. It takes out the 3-day, within 3 days of anybody from the office contacting, and puts it back to a public defender shall have personal contact with the individual.
Within 72 hours of what?
That's still the key in this one, and there's no language that's been offered yet that clarifies that to start with. Even back to the original language, which has no qualification for that.
I mean, you're only qualified to get.
All right. Is there?
Hold on, Mr. Chairman.
Yes. Yes.
I'm not sure.
Yes.
Here I am. I'm not sure how that is. That different than the Abrams amendment?
Well, it does, and it said that it leaves the in order to obtain language services. I mean, that's the order to obtain the public service request, and it goes from that part. That's the only difference that I had saw leaving the language. It had come out of committee, and the in order to. I mean, if there's a difference, then
I think if there's a difference, it's not huge. All right, now everybody understand the amendment. There seems to be, did you have a question or something else that you want to do?
The substitute motion by way of reconsideration.
Is it a substitute motion or is it?
It's a substitute amendment that would adopt in whole the Abrams amendment.
A change of heart.
No, it's a substitute.
No, he's making another motion.
Move withdraw.
Which incorporates the Abrams language as stated by Representative.
Well, no, it's going to have to be stated by you. It's going to be the Levitas amendment. Otherwise, it's going to be ruled out of order.
Mr. Chairman.
Is that it?
Is that your? Well, that will be my motion. If you would like, I would have Representative Abrams come over and whisper in my ear, but her language is stated.
No, you don't have to restate the language, but it's going to be your motion.
My motion is to restore the original language.
All right. All right.
I'll second Mr. Levitas's motion.
All right. Is there any further discussion by any members? I've got a lot of blinking lights. Parliamentary. Hold on 1 minute. I have Mr. Beard.
Okay, we're going back to restore the original language, and we're striking lines 1 through 9.
Correct.
On page 28.
Correct. Any further questions? All right, Mr.
What he said.
Representative Mangum, I'm trying to find your. I think that's you.
Okay. Just.
Well, just so I can understand, once we vote something down, it is proper to move to reconsider something immediately, or can we reconsider it tomorrow, for example?
Well, what has happened is Mr. Levitas has made another amendment, is the way the chair is ruling on it, without a motion for reconsideration.
And I have seconded.
But I'm trying to inquire of the chair, parliamentary procedure, as to whether or not this committee will, and I know you're not the regular chairperson. First of all, I do know.
My name is Robert, if that helps.
I understand that. However,
Did Robert rule?
I want to since I thought we were going by Robert's Rule of Order.
We are, but they're my rules. No, I'm just teasing.
Would a motion for reconsideration be proper after something has been voted down and we are considering anything else beyond that if there was no notice of...
To be quite honest and to answer your inquiry, I'm not sure whether or not a motion to reconsider would be proper, which is the reason that I encouraged Mr. Levitas to, since he was the deciding vote, to make the change on his own. If the member is concerned that there's some slight intended toward Representative Abrams, that is the farthest thing from my mind.
I'm not doing that.
We're trying
I'm really preparing for future events because
I
do know of one other committee where something died and it resurrected.
Well, you
and I just want to know in this committee.
If you rely on Robbie's rules of order, you're probably going to be in deep trouble later. That's all I
can
tell you.
Thank you,
Mr. Chairman.
All right, let's move along now. It's getting quite late.
Mr. Chairman.
Yes.
I have seconded Mr. Levitas's amendment. I want it to be known at the committee at this point. Mr. Levitas's amendment, which will restore this language back to the original before the committee. Upon approval of that amendment, I will withdraw my amendment.
Thank you. All right. Another question from Mr. Bearden.
Before we take this up, I'd just like to ask the author of the bill, are you something that says a friendly amendment, or would you like the original language?
All right. Thank you very much.
It's the friendliest one out there.
I can mess that up for you real quick if you want me to.
All right. There has been an amendment suggested and seconded. It has been accepted by the author, and I'm sure Ms. Travis has that amendment and understands what it is. Do you need to withdraw your other amendment formally?
He did.
Not until after we approve this.
All right, it's approved because he accepted it.
Good, then it's withdrawn.
All right.
I make my, and it supersedes it anyway, so there's no need, but mine's withdrawn.
All right. Did you have a further?
I had a parliamentary inquiry, Mr. Chairman.
All right.
I just want to know what the posture is of the committee with respect to Section 28.
Back to the original.
The original current statutory language, or the original language as proposed?
Current statutory.
It's the language that you see struck on page 27.
That's
restored.
Yeah. Lines 1 through 9 on page 28 are.
That's right.
Gone.
No good deed goes unpunished.
All right, I still have some blinking lights. Representative Abrams.
I have one final amendment that will likely languish and die quickly, so if I can get through it.
I know that last one hung around a long time.
Only when Kevin did it. That was the problem. It's page 10, line 25. And it will be beginning at line 25. Page 10, this is section 13. And this is in response to concerns raised about juveniles. Starting on line 25, it would strike after the comma, or juvenile offenses punishable by imprisonment, comma. You would then skip the next three words in comma, and you would also strike in the case of a juvenile whose parents earn, comma. So you would, in essence, strike any reference to juveniles in section A. And then in section B, you would strike on line 30 the word a in front of juvenile and replace that with the word any. So in essence, this would read that section A, any person charged with a misdemeanor, comma, violation of probation or municipal county. Oops, I'm sorry, I did one thing wrong. I need to keep offense in. Yes. I need to keep in, let me apologize. I need to keep in the language offense punishable by imprisonment who earns. So it would read, a person charged with a misdemeanor, violation of probation, or a municipal county, or offense punishable by imprisonment who earns less than 100%. So it would strike any reference to juveniles.
Municipal or county offense punishable by imprisonment.
Correct.
All right, there's been a motion. Is it seconded?
Second.
There's been a motion and a second. Is there any further discussion? Does the author accept the amendment? Excuse me, is there an objection? You don't understand it?
So the intent of the amendment is to, certainly, a person charged with a misdemeanor, violation of probation, or a municipal or county offense punishable by imprisonment who earns less than 100% of the federal poverty level. So it would simply strike the reference to juveniles. And then in line 30, you would change A to any so that it captures, because the preceding language says a person charged with a felony. So to avoid any confusion, you're also saying that any juvenile whose parent earns less than 150%. I see a quizzical look, so tell me what I need to fix. A person charged with a felony who earns, comma, or in the case of any juvenile whose parents earn less than 150% of the federal poverty guidelines. Okay. The intent being that you only reference juveniles in this section, but it covers any juvenile who has committed an offense that would trigger the section. Correct. No, not a felony. That's why I was changing it to any. So that's why I said any juvenile. How would I fix this so that it? Before I go any further, is this something that you would accept as a friendly amendment? Should it be sufficiently corrected?
May I, if I understand, Representative Abrams, the intent of your amendment is to have the eligibility level for juveniles made 150% in every juvenile case. As much as I love and respect you, and you know I do, I can't accept that as a friendly amendment.
All right, there has been an objection to the Abrams amendment. Mr. Ramsey, did you have your button? Did you? Miss Benfield.
I'm trying to be quick because I've got to pick up 2 children who are about to, I don't know, child care is about to call me to get my kids. But the way I read this, because there's been some discussion over here that says, well, in every single case, a juvenile must get a public defender. The way I read this is the language in lines 34 through 36 kick in for juveniles. So with Representative Abrams' amendment, were it to pass, if you exceed 150% of the poverty level, you're a juvenile, you're not qualifying for representation. So Is that correct? You have to be 150% of the poverty level or below if you're juvenile to qualify for a public defender. That's what it's doing. It's not saying in every case you could, if you're really rich, your parents are really rich, you're not qualifying for indigent defense. Juveniles aren't. Lines 34 to 36 apply.
Mr. Chairman.
With the chair's permission, I would just point out to members of the committee, juveniles are not imprisoned; they're detained. So I think that that distinction has to be remembered there.
Unless they're charged with
one of the
7, now 10 or 11 deadly sins. All right. Does everybody? Is there more discussion? Mr. Setzler.
To the author, what would just so I have a feel, what would the impact be if we went to 150 as the income threshold? Is that going to drive the cost up and the number of cases? What's the
Well, at 150, you're going to capture more cases with increased cost than you would at 100.
That'll break the current budget.
Well, I mean, this is not a and it became a lot more broke yesterday or Monday. I don't want to get into budget issue. I mean, I'm happy to talk about those. I mean, we all know the discussions of the budget on this issue, as well as education and health care and transportation and water and all the other things we're talking about this session. And it would that we could fund all of these things at a perfect level, but that unfortunately is not the reality.
All right. Does everybody understand that was an Abrams amendment, the last amendment. All right. It's now time to vote. There has been an objection. All those in favor of the Abrams amendment, please raise your right hand.
This is lonely.
Those opposed? All right. Are there any further amendments? Mr. Mangum.
Yes, on page 14. Line 27. Insert the words, the Georgia Association of African American Attorneys, comma, the Gate City Bar Association. Line 27, page 14.
All right. Okay, there's been a amendment proposed and a second. Does everyone understand the amendment? Is there any objection to the amendment?
I want to ask the chairman, is that a friendly amendment?
I'm just going to make an observation, Representative Mangum, and I hope you will receive this in the spirit that it's given, but it's not an objection, but from sitting on the Appropriations Subcommittee, it's my understanding that the percentage of females, for example, has dramatically increased in our prison population. And we also have an increasing population of Hispanics in Georgia. Do we also want to visit, including representatives from those organizations like the women's lawyers or Hispanics? And I'm just asking that as an observation.
I would have you know that the G-Quad-A is headed by a female. And I would also have you know that the Gate City Bar has had its members who are female. And my feeble attempt here, this is not the other stronger amendment, Mr. Chairman, I would want to remind you. This is...
No, and I'm mindful of that.
This is just saying that you acknowledge that they even exist. Now, really, but I understand your concern may be, but I would say that if you would look at history, what happened, women had more rights after certain people started the door, opened the door, and if you want to close that door, oh gosh.
I'm not wanting to close any doors.
All right, now there's a motion, and
would you prefer that either one of those rather than the other?
Well, I think one.
The G-Quad A, which is more inclusive, rather than the Gate City Bar, and I'll withdraw the Gate City Bar if the chairman would.
And I have no objection.
all right. So you're not objecting to the Georgia Association of African American Attorneys?
I think it's called the Georgia Alliance of African Americans.
Okay, it's G,
All right.
4 A's. That's all I remember. I'm sorry. Georgia Alliance. She is correct. In fact, was it in the previous bill? I don't know what.
All right, now let's try and keep it together.
We had it in
because
A bill.
The hour is quite late.
I remember it was in A bill.
All right, look, the hour is late. I want to try and keep some order here. All right, I have some members who wish to ask questions or make comments. There is a motion. It's now it's been accepted. There's been an amendment, and it's been accepted by the author. Is there anybody else that wants to object to it before that happens? I don't hear anyone. All right, it has been accepted. All right, are there any other amendments?
Yes.
Mr. Levitas.
This is on page 33, line 15. Strike the word 24, the number 24, and substitute it with 72. Page 33, line 15. Strike the word 24, replace it with 72.
All right. Is there a second? It's been seconded. Mr. Chairman, do you accept that as a friendly amendment?
Sorry.
I can explain. I just didn't explain. I'll be happy to.
I would waive the explanation if you would just restate the amendment.
It is to strike the number 24
Page.
on page 33, line 15, and replace it with 72.
Okay, I'm sorry.
I'll explain that if you want me to, but I'll offer to do.
I see. Okay. Okay.
I think probably for the benefit of the rest of the committee, because I sure don't know why. Tell me.
It's very simple. Because
All right.
if it happens on a Friday, under this, you'd have to give that notice on a Saturday. So this just gets it to Monday. If
Okay.
that happens. That's all that it's intended to do.
All right.
Substitute motion.
All right, substitute motion. Hoist on my own petard. Go ahead.
Or as soon as practical thereafter, after 24 hours, comma, or as soon as is practical thereafter. Therefore, that would, if you have a holiday or whatever else, because it could practically be 4 days, you could be out. But 24 hours or as soon as practical thereafter.
All right, is there a second to that amendment? I'm sorry? Is there a second? I'm not hearing a second. All right, that amendment is dead for lack of a second. All right, we're back to the amendment that has been explained, and I believe that that amendment is in the process of being...
Can we do a substitute
One working day.
Huh?
One business day.
I'm sorry. All right, do you have an objection?
I'm not sure what the amendment is right now.
As I understand it, there is an amendment.
You're asking me if I have an objection to an amendment that didn't get a second?
No, the 72-hour amendment, which did get a second.
I thought that died.
No, that was my.
That was his amendment.
Or as soon as
Oh,
practical.
okay, I beg your pardon. All right.
The director is telling me he thinks that maybe within one business day might even be a better solution.
Can the author amendment make a substitute to the author's own amendment?
Yes.
Okay, then I would make a substitute motion to replace 24 hours
with the phrase one business day.
All right.
I don't know, Madam Council, that has to be a number or a letter. Matters not to me, but whatever
That
the
works, Jill.
craftsmanship is on that.
Okay.
All right. Okay, that is a motion, and I assume that is the chair is going to accept that as a friendly amendment. Is that correct?
Yeah.
All right. That has been accepted as a friendly amendment. Are there any other amendments? All right. Is there what's the committee's will? Yes.
On that amendment, Mr. Chairman,
Mm-hmm.
is it a precondition for this verification to happen before a person is able to see counsel for that process to happen, or is that unrelated completely?
I'm going to ask Director Crawford for a very short answer based on current practice.
I'm sorry, I didn't even get the question. I was trying to answer a question.
I don't know if my mic's working, but I guess the question is, if a person is booked in on Friday and wants to see counsel, is this income verification going to have to, in any circumstance, have to happen before the process of obtaining counsel can happen, or do those things happen in parallel?
No.
Unrelated.
I think the answer is no.
Mr. Knox.
Mr. Chairman, with all due respect, I know you've accepted as a friendly amendment, but I think it's important for the Public Defender's Office to know that they've got somebody that's eligible for their services. And that being the case, I think that's all this paragraph requires, is that they notify them. It doesn't mean they got to show up and do anything. It just says once you got to give them notice. That could be by fax. It could be picking up a phone. It could be sending them a letter. It just says send them notice within 24 hours. I don't know why. I'm not sure I understand what the problem is.
Ms. Abrams, did you have something?
Well, it was a similar concern to the one raised by Mr. Knox, and I was going to suggest one business day.
All right. Okay. What is the will of the committee reference this bill? All right. Mr. Bearden has made a motion do pass by committee substitute. That has been seconded. Is there any further discussion? I just have one other thing I want to say. I didn't make it as an amendment, but when this bill originally passed with that $50 in there, I think most people who were in the trenches knew that $50 was not going to be collected on a regular basis, and I'm not sure that raising it to $100 is going to necessarily improve the collection rate. So maybe when I know that this committee's done everything it can do, but just make that point. All right.
And I want to thank the committee for their hard work today.
Thank you. Thank all of you. Oh, vote. All right, vote. All those in favor of do pass as substituted. Do pass. Yeah, raise your hand. Any opposed? There we go.
Yes.
Yeah, one business day. Thank you, ladies and gentlemen.
I'm sorry I wasn't out. That's all right.
Hey, thank you, Eddie. Good to see you.
Matt, just like that.